morning, and may it please the court. Eric Grant for plaintiffs and appellants, the Landeros family. With the court's permission, I would reserve 5 minutes for rebuttal.
All right. I'll try to help you out, but keep your eye on the clock as well, please.
Thank you, Your Honor. In a direct examination scripted by defense counsel, a putatively disinterested public servant presented knowingly false testimony about his pre-existing relationship with defendants and their counsel. Dr. Jason Tovar, whom defense counsel called the key witness in this case, was presented to the jury as an independent and impartial expert who could be trusted more than the mere hired gun retained by plaintiffs. But all that was a lie. Both counsel and witness knew that Dr. Tovar was being personally compensated.
Were you the counsel below?
I was not, Your Honor.
What did counsel know about Dr. Tovar's situation and arrangement at the time of trial?
Plaintiff's counsel knew that Dr. Tovar had conducted the autopsy of Mr. Landeros, but plaintiff's counsel did not know of the relationship between defendants and Dr. Tovar. Plaintiff's counsel did not know that nearly 2 years before trial, that counsel and Dr. Tovar had entered into a written fee agreement expressly made for expert consultation with defendants.
But he knew that they were going to call him as a witness. He was on their witness list.
Yes, Your Honor. There was no surprise that Dr. Tovar...
Both sides had him as on their witness list.
Exactly, Your Honor. And so our contention is not that Dr. Tovar's appearance was a surprise.
Right.
Our contention is that the relationship, the financial relationship that had been going on for at least 2 years was not disclosed. And so that rendered the testimony at trial false, and counsel's vouching for that testimony to the jury false as well.
So let me ask you this, on this aspect of your claim, do you need to show some sort of prejudice or you're automatically entitled to a new trial? Or what's the test for evaluating your claim?
Yes, Your Honor. For 2 of the 3 bases for a new trial, 2 of the 3 grounds, false evidence and discovery misconduct, the test from this court's opinion in the Jones case that we've repeatedly cited in our briefs is that the failure to disclose prevented the plaintiffs from fully and fairly presenting their case. And it's not required to establish that the result would be different.
So, in other words, if Mr. Gallipo, I think he was the trial lawyer.
Yes, Your Honor.
If he had known that the doctor had this agreement, he would have brought that out at trial? Or he would have brought in another expert, or what?
2 things, Your Honor. Yes, he would have brought that out at trial, but first of all, plaintiffs would have deposed Dr. Tovar before trial and explored the financial relationship, and also explored the extent to which Dr. Tovar's opinions would go beyond his autopsy, such that plaintiffs would not be blindsided by those new opinions at trial.
What was there? I thought there were really only 2 theories about how the victim, the decedent, may have died. One was by asphyxiation, and one was by cardiac arrest. Is that right?
Those were the competing theories at trial, yes, Your Honor. And crucially, the defendant's theory, as articulated by Dr. Tovar at trial, of cardiac arrest was not in his autopsy report. That simply does not appear there. And so that was a new opinion at trial, and that's one of the bases for our claim of discovery misconduct.
They had another the defense had another doctor, right?
Correct, Your Honor.
And he opined that it was by cardiac arrest.
I'm not certain that he did, Your Honor, but the crucial point, I think, is that as defense counsel himself articulated in his opening statement and all throughout trial and in his closing argument, these were two hired guns, but Dr. Tovar stood above the fray. The jury could believe him particularly because he was completely independent, in the words of the defense counsel. And so that had we submit, dispositive effect on the jury's verdict.
Let me ask you this, counsel. Why wasn't Dr. Tovar deposed, given that he was on the witness list? Was it because you were or Mr. Calif was under the impression that he wasn't going to be an expert witness?
No, Your Honor, he was not deposed because he did the autopsy on Mr. Landeros, and his autopsy report.
Right. No, that's what I mean. The autopsy report did not pinpoint the cause of death that he testified to at the trial, right? So when you saw his name on the witness list, what did the plaintiff think he was going to testify to?
To his autopsy report alone, Your Honor, because under Federal Rule 26A2, both paragraph B and C, if he were a retained expert, as it turned out that he was, and if he were going to give a new opinion.
Right, the disclosure would have to be different. So from the plaintiff's perspective, he was not going to be the witness testifying to the cause of death at all. Is
Correct,
that right?
Your Honor, or at least his testimony would be confined to his autopsy report, which in plaintiff's counsel's view was not harmful to plaintiff's case. And so that's why this is discovery misconduct, because as a retained expert who was going to give a new opinion, he would have had to been disclosed. Plaintiffs would have had the opportunity to depose him, to test those new opinions, and to explore whatever financial relationship existed.
Let me ask you this. I can't remember all these cases. I read all this stuff a while back, but what was the district court's, the essence of the district court's ruling denying the motion for a new trial?
The essence of the district court's ruling was that the testimony was not false. And we submit with respect to the district court that finding is clearly erroneous. And the clear error there vitiates any deference that this court might otherwise give to the district court's ruling. It simply defies credibility to look at the record, to look at the testimony and counsel's vouching for that testimony, and we summarized.
But what is it precisely was the false testimony? Is it the use of the word independent?
Yes, Your Honor, that's one. So we've cataloged those on page 11 of our opening brief. Mm-hmm. So the testimony was Dr. Tovar hasn't been hired by either side, when in fact he was hired by defendants. The testimony was that Dr. Tovar is independent. And then counsel doubled down on that in his closing argument to say that Dr. Tovar was completely independent.
I guess the independent seems a little subjective. Like, what does that exactly mean? I mean, it's not like he fed him the lines. He used his independent judgment.
Well, to go on, Your Honor, the testimony was Dr. Tovar is not affiliated with the defense. And that was the testimony at trial. And of course, at the post-trial hearing, Dr. Tovar admitted that he was affiliated with the defense.
So, and Dr. Tovar gets paid. Even if he's not retained as a witness, he gets paid some money. Over $300 per hour is paid to someone, either the county or to Dr. Tovar directly. Correct?
Crucially, Your Honor, if in the normal course, it would be paid to the county of Sacramento to reimburse the public agency for the time of its employee.
Right. So the theory is that now, because it's not going to the county, but it's going to Dr. Tovar, that it might shade his testimony in some way?
Well, he's a retained expert, Your Honor. He's working for the defendants. And it's not to challenge the credibility of his medical testimony. But of course, that relationship would be explored by plaintiff's counsel on cross-examination in the normal course if plaintiffs had known of the undisclosed fact. And just to go on, again, additional testimony, Dr. Tovar lacked any affiliation with the Elk Grove Police Department. And of course, he had an affiliation with defense counsel. And I see that
Yeah, I know you wanted to say 5 minutes.
Thank you,
I
Your
forgot
Honor.
to remind you.